filed in the case that was transferred from Miami-Dade County. So if they want to have this reheard, it'll have to be filed in this case instead of the Dade County case. So I'll say the parties are no show. It's now 3:10 p.m. So that brings us to our last case on the docket, Charles Rosalie versus Veronica Konechny. Sorry if I'm butchering either of your names. COWE 21012996. Mr. Scott, this is your motion, sir. I see that you filed a verified motion, which is excellent on the matter. So verified motion to set aside the default judgment. Mr. Scott, did you want to proceed on anything else in your amended motion?
I do. I just want to, if you could place me under oath, Judge, so I can supplement. And I apologize ahead of time. I'm suffering from a cold and my voice is crackling. But if you could place me under oath so I can supplement my sworn motion, I'd be grateful for that.
Okay, no problem. Raise your right hand for me. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, thank you. You can put your hand down and state your name for the record.
My name is David Scott. I'm an attorney licensed to practice in Florida. So, Your Honor, I spent some time today trying to figure out how on earth I could have possibly missed this. And what I discovered was that my staff had received the notice resetting it to the 21st. At some point I was going through and I remember seeing an email canceling the hearing. That email canceled the February 1st hearing. I went to my calendar and inadvertently canceled out the 21st rather than the 1st. And that is what happened. So it made it to my calendar. I did not realize that it had been placed on the 21st. And when I saw the email canceling the 1st, I inadvertently canceled the wrong day. The case law is clear. I can share this one simple case going back as far as 1982. The 4th DCA has said that an attorney who places the incorrect date on their calendar or fails to properly note a calendar does constitute excusable neglect. A client should not suffer for the attorney's mistake. As far as a meritorious defense, I did originally file a motion to dismiss citing detailed case law suggesting that the complaint was facially insufficient for failure to comply with the statute and list certain values, and also how he came into source of ownership of the things that he complains of, to simply have a default judgment for $8,000 based upon that that complaint being as insufficient as it is would be manifestly unjust for my client to suffer that based upon a calendar error by her attorney. So I'm asking the court to set aside the default judgment, reschedule it for a trial, Judge, with my sincerest apologies to the court and the opposing party.
All right, no problem. Mr. Rosalie, briefly, I saw your response, but is there anything additional that you wish to put forth?
Yeah, Mr. Scott was served on January 20th with the reschedule, and he's basically not claiming anything that's out of his control. If it's this negligence, I don't see anything in any case law that excuses him. I waited a year for this trial, and it was e-filed. If it was his negligence, even pursuant to the rule 1.540 section B of the Florida Rules of Civil Procedure, there's nothing here that states anything he just stated. I don't see any reason why he should have this judgment set aside for the reasons that he's just verbally put forward. So, and then also he says something about, and he starts to argue the case, and we're not even arguing the case about what the case entails and what I've done and what I haven't done. But I waited a year and she's still in control of my property.
All right, thank you. The case law that he's referencing is Mary Hall versus Eleanor Florence Byington. It's 421 Southern 2nd 817, 4th DCA Court of Appeals, November 17th, 1982 is when that case came out. I'm very familiar with the case. So based on that case law and the fact that it is a sworn to verified motion, I am going to grant his motion to set aside the default judgment and the default. And I'm going to give you guys a trial date right now, so that way there can be no confusion as to when the trial is. Okay, I did have a trial on the afternoon of March 24th that just washed, so I can put you guys in for 1:30 to 3:30 on Thursday, March 24th, 1:30 to 3:30.
Perfect, Your Honor. Thank you.
Mr. Rosalie, that works?
Reluctantly, yes.
Okay. All All right, so failure to appear at the trial could result in sanctions such as dismissal or default. Just so the parties are aware, I am going to send that new notice of trial date today for the parties at 3:24 at 1:30 to 3:30. It is going to be on Zoom. And all motions will be heard beforehand. So if you do have the motion to dismiss, just make sure that it's properly filed and noticed, Mr. Scott, on Mr. Rosalie, so we can hear the motion before the trial.
Same Zoom instructions, Your Honor.
It's going to be the same Zoom instructions. It's about 2 weeks and 2 days from today.
Thank you, Your Honor.
All right, thank you both. Everybody stay safe, okay?
Judge,
Yes, ma'am.
is council going to submit the
Reiterate
order setting
March
aside
24th at-
the default judgment?
Yes, Mr. Scott, you need to submit the order setting aside the default judgment and the default, sir, so that we can reinstate the case.
Thank you, Your Honor.
All right, thank you.